Guys, I want to talk with you now about a concept that is not always discussed in evidentiary law because it's structural in nature. It's the type of thing that trial lawyers think about. And you need to remember that a trial lawyer deals with potential evidentiary issues every day. So when they have a client come in the door, they're thinking about the evidence question that may arise at trial. When they deal with a piece of evidence that's discovered in a case file, as part of their thought process, they're going, now, if I have to admit this at some point, how am I going to do it? Well, what trial attorneys do is they look at evidence contextually. Now, what do I mean by evidence in context? That's a structural approach to what you think about evidentiary law. And a practical person who uses evidence to actually do something with it is always thinking about how it fits in connection to everything else that's happening in the representation of a client. They see the context of the evidence, the context of the rules, and they apply evidence and analyze evidence in that fashion. Now, I make an argument that makes a lot more sense to do that when you learn evidentiary law and when you develop your evidentiary legal skills. Think about it for a moment. Have any of you ever played a board game as a child? I bet some of you have played the game of life or the game of Monopoly, maybe Parcheesi or Sorry. My children's favorite was Hungry Hippos, but that doesn't work as well for this analogy. When I play a board game, there are a couple of different ways that I can learn to play the game. How many of you have opened up the box top and read the rules on the other side? Okay, as soon as you read the rules, what did you do? You looked at the pieces of the game, didn't you? You picked them up, you held them in your hands, you moved them around on the table. If it was a game of life, you spun the wheel. If it was Monopoly, you rolled the dice. You held the little houses in your hands. Now, why did you do that? Because you were using the other portions of your mind to place in context the rules that you'd read on the box top of the game. That's the way human beings work. We have to see stuff in context to make it apply. Many folks teach you evidentiary law by giving you the rules, but never allowing you to see the board that the game is played on. They never allow you to pick up the pieces and play with them. They never let you do a direct examination. They don't even want to talk about how an evidentiary argument might come up in an objection. Why? Because they've made a decision from a teaching perspective that the way in which evidence is used is not important. Let me say that again. They've decided from a teaching perspective that the practical application of the law does not have value. Now, you need to make no mistake about it. That is a specific choice. And that initial choice has huge implications for whether or not you'll understand the subject by the end of the semester. If you have a professor who cannot bring the evidence into context for you, you're going to have a problem seeing how the pieces connect by the end of your study. And that's unfortunate. There are some important appellate cases in evidentiary law, probably less than 7, maybe 10, in all of the history of the United States that you need to know to properly be able to try a case and to apply evidence. You need to understand every rule, but you don't need to understand every case. So I suggest to you that the way that you learn evidence is through its application. If you're learning this and you're not in a trial advocacy class, you should be. If you're learning this and you've never seen a trial, go find one and watch it. And by the way, Law and Order or Ally McBeal or Boston Legal does not qualify as watching a trial. It's great entertainment, it's great theater, but you don't get the ebb and flow of the evidentiary argument. Once you understand evidentiary law, you'll see what lies behind it. Now, why is it so important, structure? Well, let me give you 3 things that you should think about every single time you are dealing with a question of whether or not a piece of evidence is admissible. Because these 3 questions, if applied consistently, whenever an evidence question comes up, will help you sort through the process. The first one is, am I in a criminal or a civil proceeding? Am I in a criminal or a civil proceeding? The question of criminal or civil proceeding is important for several reasons. The first one, the largest one, is the confrontation clause. Because if I am in a criminal proceeding, the defendant has the right to confront his or her accusers. And that has direct implications from hearsay question standpoint. Supreme Court jurisprudence in Crawford, Washington v. Davis, Hammond v. Indiana, Melendez-Diaz has clearly shown us that the confrontation clause is alive and well in criminal cases where hearsay is at issue. Now, if it's a civil case, there is no confrontation clause issue because we're not fighting over life or liberty, we're fighting over money. And when we fight over money, the Constitution, as far as the confrontation clause applies, does not work in the same fashion. So that predicate question, am I at a civil or a criminal proceeding, tells me at least at a minimum whether or not I've got to worry about the Crawford Doctrine. But it goes further. Because the way in which character evidence under 404 is treated differs in a civil or a criminal proceeding. In a criminal proceeding, the defense holds the key to the door of character. And I will talk in a separate lecture about how that door is opened, what happens when you open the door, and what happens when you keep it closed. But for now, remember, the defense holds the key to that door. And if I'm in a criminal proceeding and I don't want to make character relevant as a defense counsel, the state can't open that door. That has huge implications for the way in which Federal Rule of Evidence 404A and 404B are applied, which means when you're dealing with an evidentiary question on an exam or in real life, knowing whether I am in a civil or a criminal proceeding helps me sort through the options of character under 404. But it even goes further. If I'm in a criminal proceeding, the hearsay rules are different. For example, if I'm in a criminal proceeding, the only party opponent that exists is the defendant. So the hearsay exclusion, admission by a party opponent, is not available against anyone other than the defendant when the state is attempting to offer that statement. Now, in a civil case, I can have the plaintiff and the defendant, and anything that either one says is potentially admissible under an 801D exclusion for admission by a party opponent. And in a civil case, I can call the opposing party and force them to testify. So knowing whether it is civil or criminal, it's one of those gateway questions that we ask whenever we see an evidence issue, whether it's on a multiple choice, whether it's in court itself, whether it's reviewing an appellate case. What else do I need to know? I need to understand where the heck I am in the process when the legal question arises. Now, what do I mean by that? I mean you've got to situate the proceeding. You've got to understand. Am I on direct? Am I on cross? Am I on redirect? Am I on recross? Is the person on the witness stand one of the parties to the case, or is it merely a witness? Why is this so important? Because if I identify correctly whether I'm on direct or cross, then I can properly interpret the application of Federal Rule of Evidence 611 or 613. If I identify correctly whether I'm direct or cross, I can properly interpret whether the form of the question or the answer that is given comports with the requirements of 405 if they're trying to offer character evidence, or 608. By the same token, if I know whether or not it's the witness or a party to the proceedings, I can better understand and apply the hearsay exceptions that are normally relevant to someone on the stand. So knowing where I am in the process, who it is that's testifying, is crucially important to my analysis of what rule applies properly. And we'll look at that when we look at each rules. And then I've got to understand, finally, the purpose for admitting the evidence. I need to know, am I trying to get this in substantively for the truth, or am I getting it in to impeach the credibility of a witness? Because the standards to allow me to ask the question and get the answer are different if it's for impeachment as opposed to substantive use. If you want to think of it as two trash cans that I'm going to throw evidence into, the substantive use trash can has a smaller mouth. It might be just as big, as the effect on the listener or the impeachment trash can. But it's easier to get in evidence for impeachment purposes as opposed to substantive purposes. And I'll show you how that works in a very real example in the presentation that we do talking about impeachment with prior inconsistent statements. So remember, I need to know, first question, is this a civil or a criminal proceeding? And I do this every single time I have an evidence question. The next thing that I need to know is, where am I in the process? Am I on direct or am I on cross-examination? Who is testifying? Is it a party or is it a witness? And then the third thing that I need to understand is the purpose behind the offering of this question. Am I trying to get at a substantive issue such that I have to admit it substantively, or am I merely looking to impeach the credibility of someone who has testified at trial? If you'll keep those three in mind, you'll be well on your way to properly analyzing these sorts of evidentiary issues. Let's move on now and look at some preliminary matters.